Mr. Chair. Mr. Gupta, is Gupta?
Gupta is fine.
Okay. You were discussing this case where, after discovery, you found out that there was a license. Did you file a Rule 11 there?
We, if I recall correctly, we sought to recover our costs and fees after the plaintiff approached us and wanted to drop the suit, and we were unable to because we could not make a showing that it was an exceptional case. And that's where I think the standards are really high right now, and the plaintiff was able to walk away knowing.
I'm missing something. Tell me about this license. You discovered that it was...
So we sell, in this particular case, the products that were accused of infringement were generally hardware products that needed some operating system software. And in this particular case, the operating software came from 2 or 3 different sources. Each one of those companies had previously obtained a license to the patent from the patent assertion entity, and the license covered downstream users of that operating system software. So understanding that that operating system software needed to work with pieces of hardware, the operating system provider had obtained a license that was broad enough. When that patent was asserted against us, we did not know, and we had been trying to figure out what sort of licenses were already in place with that patent. That information was not provided to us readily. Now, it is our belief that the patent holder knew all along, the patent assertion entity knew all along that these folks had indeed been licensed, and they had kept that information away from us as long as they could.
I may not understand this, but it seems like if there was a license, that it was that's when it was a slam dunk.
Yes.
Well, and how could you not have succeeded? Was this the judgment of the court under Rule 11? It doesn't seem like the facts as you describe them could even could a judge find other than to award fees?
That is part of, I believe, the reason why this bill is actually targets or has directed remedies for some of the challenges that we face today. In this particular case, we had to go through months of discovery to ultimately get that document or get those set of facts. And even after we were able to establish that there was indeed a license, the patentee or the plaintiff is simply able to walk away and without any financial accountability for having put the defendants through this very expensive process.
And Rule 11 wouldn't have covered that?
We did not, it's not.
You did assert Rule 11?
There are Rule 11 sanctions that are available, but we sought to recover fees under Section 285 for frivolous, for having initiated this action, and our case was deemed not to have satisfied the exceptional case standards.
This is somewhat, as I understand it, patterned this remedy or change under the Equal Access to Justice Act. Are you familiar with that?
Somewhat familiar with it.
Are there not some countervailing standards whereby if one side has protracted the litigation and caused additional expenses that the award can be reduced by the judge?
In patent cases, it's very rare that a prevailing defendant is able to recover their fees and costs, and generally,
right, and this would change that.
This would put some financial accountability back on the abuse of plaintiffs.
And shouldn't, just like the Equal Access to Justice, shouldn't it be balanced though? That if there's certain harm or fault on the defendant, maybe in expense of litigation, that should be something the judge takes into consideration?
And I think this bill talks about, if the non-prevailing party takes positions in litigation that are objectively baseless, then there is an opportunity for the prevailing parties' fees and costs.
So you think that should occur, whether it does or doesn't?
Yeah.
Mr. Kapos, let me ask you this. Mr. Watt asked you, what are the things that you find that are okay in this bill? And in response to Mr. Smith, you said a few things that maybe weren't. What are the things that you think are most egregious in this bill?
Well, I wouldn't identify anything as egregious. I think that
are there the things that are your least favorites? The things the things that we shouldn't be in this bill. How about that?
Yeah. The one thing that comes to mind. I think it's a very productive discussion, but on balance, as I've mentioned, I would tend to leave the covered business method situation the way it is, given much in flux and how early in implementation that is.
Is that the only section that causes you any concern? Otherwise, you're for this bill?
Well, with all the points that I've raised, relative to the judiciary and letting the judiciary play its role, et cetera. I can't think of a provision that as I sit here, though, that I would say is completely unacceptable or bad policy per se.
It's hard for me to even comprehend that there should be a bill, because Mr. Smith was such a great chairman and passed such a good bill that I supported, that I wouldn't think we need to be here this year. But apparently there was something even he missed. I yield back. We have a new chairman.
Yeah, well, he's not new, but he's
He's not new. He's 20 years
right.
great service to the country. I yield back the balance
Thank
of my time.
First of all, I'd like to also say, Mr. Conyers, you're a man of a very wonderful person as an individual, and I have really enjoyed my 21 years of association with you, and your connection with Alabama, and we appreciate that. With Rosa Parks, came to work for Mr. Conyers when she moved to Detroit. So, thank you.
Until she retired.
Thank you. Just reviewing this, the enhanced pleading standards appears to be somewhat non-controversial. The fee shifting to discourage frivolous lawsuits, there seems to be a lot of support for that. The transparency, the discovery limitation, at least initially, seems to be, we're not getting a lot of pushback on that. The covered business method patent program seems to be controversial. I noticed that, in fact, in my case, Microsoft, IBM, Business Software Alliance strongly oppose expanding the program. We've got Google, National Retail Federation, Food Marketing Institute, Internet Association, they're for it. I would think Yahoo would be for or against it, I'm not sure. Mr. Kramer?
The covered business method program?
Yeah, expansion of it into include first issue patent.
Yeah. Thank you for the question, Mr. Chairman. Certainly, we are in favor of trying to find low-cost alternatives to litigation, particularly in situations where we feel like the patent quality is very low, right? We feel like in that situation, we should have the ability to go back to the patent office on any ground and address that question with the patent office rather than spending millions of dollars in litigation. Now, I understand that there's debate on both sides of the issue with respect to the scope and the length of this program, and we're certainly happy to work with the committee on that point.
And I know Mr. Capos, he's testified as to sort of an alternative approach to what is in the legislation.
Well, on balance, relative to covered business methods, what the alternative, if I can call it this, is to return to full funding for the USPTO, because it's doing a lot to bring to life those procedures, and if the agency's funded, it'll do more.
And in fact, there are other requirements in this bill which you would have to spend additional money on developing software. So
yeah, exactly right.
Mr. Gupta, what is your position on expanding the covered business method? You know, on financial services, I think it's critically important that we do it in that field in some way. But do you have any comment on covered business method program, how we should approach that?
Mr. Chairman, we have at EMC, we have generally focused on the procedures and the processes that have been set forth to deal with abusive litigation practices.
Which are the transparency, the enhanced pleading standards.
You know, fee shifting, specificity pleadings, and the like. And that's where we think the bill can really do a lot to.
So it's not
it's not a particularly relevant topic for us
All right.
at this time.
How about the stay for customer suits? That also, we're hearing two different sides of that. Would those be the covered business method patent program, the expansion of that and the stay for customer suits? Are those the two main points of conflict?
Mr. Chairman, I would just say, in my view, the stay for customer suits is not at its highest level particularly controversial. It's clearly good policy to let innocent retailers and so-called mom and pops and end users stay litigation. The issue is crafting the provision so they're not overbroad.
Right, okay. And whether or not whether it's mandatory or discretionary on the part of the manufacturer?
Well, there clearly has to be thought given to an appropriate amount of discretion including for a court, so that, for instance, manufacturers who can avoid judgments or are not reachable under U.S. jurisdiction can be accounted for.
Could you give us recommendations on that? Any of you on the panel just give us some written recommendations on how to fashion that stay for customer suits, or look at the legislation? Would that be possible?
Certainly happy to work with the committee on that. My personal view is that the language in the statute that that requires agreement between both the customer and the plaintiff, that's a great start.
Right. Yeah, and then it is, in that regard, it is somewhat discretionary. I mean,
Correct.
so.
Correct.
Mr. Armitage, and I'm exceeding by 1 second my time.
Yeah, I just had two brief comments. While I think everything in the litigation part of this bill is actually needs to be done, the real question is how. There are two issues that I'd point out. One is tying the commencement of discovery to the Markman process, the claim construction process. Does that work in all cases? And if not, is more flexibility needed? And then the rules and procedures judicial conference will be mandated to put in effect. Are those, in fact, rules and procedures too specific in the sense that they don't cover situations beyond practicing, beyond some of the concerns that the witnesses have given here?
All right, thank you. Thank you very much. Appreciate y'all's testimony. And at this time, Mr. Johnson, the gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Through executive actions, President Obama has already worked with the Patent Office to improve the quality of patents by tightening functional claiming. Patent quality is at the heart of this issue, and if we make strides today to eliminate low-quality patents, we'll make great leaps and bounds in improving patent litigation for all parties over time. The President has already made real party and interest the new default for patent applications and has worked to educate and protect consumers and other downstream users who are targeted by the patent trolling phenomenon. Now, there's no doubt that there is abusive behavior occurring in patent litigation, and it's causing harm to large and small businesses alike. So I think you are all happy with the fact that the U.S. Supreme Court has accepted cert on the octane fitness case, and will be deciding the issue of 285, Section 285. When is it, or what is the definition, or how do we construe this exceptional standard that is put forth under 285? And so now that case will be decided by the court, which is going to be looking at the legislative history, which includes input from the ABA, both sides, plaintiffs and defense, It'll be looking at various cases that have developed over the time of patent litigation, and it certainly has to be well suited to be able to construe this issue of exceptional cases. Is there anyone who disagrees with that? Yes, sir.
If the issue is, should this committee wait until the Supreme Court renders its decision, I would urge the committee not to do that. I think what the Supreme Court is doing is try to define precisely where the goalpost is placed today, and what the provisions in the bill do would actually move that goalpost for good policy reasons. So I think to some degree the Supreme Court, I hate to say is wasting its time, but certainly would be if Congress were to effectively move the goalpost.
Anyone disagree with that?
Congressman, thank you for the questions. So again, I think that I'm not going to pretend to guess where the Supreme Court is going to come out in that case, but that case is limited to its facts for that party. I think the clarification that is in the Innovation Act goes farther and is a better provision for everyone in the patent litigation system. Thank you.
So, so you're both saying that you think that the legislature is in a better position to deal with when a case is so exceptional that it requires or that it merits an award of fees and costs. My problem is the small investor and, or excuse me, the small inventor without access to the cash to commercialize the product that this invention would fit within or that it would constitute. And if there's an infringement on a patent that is owned by an individual without the cash or the resources to assert that patent, then it drives down innovation. And so I'm afraid that the legislative approach to further tightening of the ability of plaintiffs, be they patent, be they non-practicing entities or patent assertion entities, for them to be able to, on behalf of that small inventor, protect what that inventor has invented. And so I don't want us to go too far in terms of closing the courthouse doors to those types of good faith.
Thank you.
Good faith litigants, and we can't just throw a broad brush on all patent litigation and say that the majority of it is abusive, when in fact the GAO has found that that is not the case.
Thank you.
Thank you.
Of course, what it does, it just establishes